Welcome back to Law Stories. Today we are discussing a very important topic from the Hindu Marriage Act, 1955 Proof of Marriage under Section 8. Many students get confused about why marriages need to be registered and what happens if they are not. Don't worry, in this video, I'll explain it in a very simple and clear way with examples. So, let's get started. 1. Purpose of registration or Section 8 gives power to the state government to make rules for registration of Hindu marriages. Or the main purpose is to keep an official record which can be used as proof that a marriage has taken place. Important point, registration does not create a marriage. The marriage itself must already be solemnized according to Hindu customs or law. Registration only works like a certificate or evidence, which can be shown in legal or official matters, like property, visa, inheritance, etc. Next, let's see the Supreme Court direction in Seema vs. Ashwani Kumar case, 2006. In this case, the Supreme Court noticed that many people were facing problems in proving their marriage in legal matters like inheritance, divorce, maintenance, or property disputes. So, on the 14th of February 2006, the court said that registration of marriage must be made compulsory for all religions, not just Hindus. The court gave directions to the central government and all states, union territories to change their laws and rules to make this compulsory. The main aim was to prevent fraudulent marriages, child marriages, and to provide a clear legal record of marriages. When it becomes compulsory, Section 8 says that it is up to the state government to decide about compulsory registration. The state can make it compulsory, or everywhere in the state, or only in certain areas, or only for certain types of cases, like intercaste marriages, NRI marriages, etc. So, compulsory registration is not automatically nationwide under Section 8, it depends on what each state government decides. Next, non-registration does not affect validity. A Hindu marriage is valid from the moment it is properly solemnized according to Hindu customs and rituals, like Saptapadi, Kanyadan, etc. Even if the marriage is not registered, it will still be legally valid. Registration only acts as evidence or proof that the marriage took place. So, marriage equals ceremony, while registration equals official record. Next, false registration means invalid marriage. Registration can only prove a real marriage. If no valid marriage actually took place, but the parties just go and get it registered, the certificate has no legal value. Case, Shaji v. Gopinath Ho. In this case, there was no proper marriage as per Hindu Marriage Act. Still, the boy got the marriage registered only so that the girl could use the certificate for a job abroad. The court said, since no real marriage happened, the registration was null and void, legally zero. Next, the next topic is matrimonial remedies under Hindu law. There are 4 main remedies available under Hindu law. Restitution of conjugal rights, Sec. No. Judicial separation, Sec. Thus, nullity of marriage, Sex. 11-12, divorce, Sex. 13 onwards. We have already seen judicial separation. In this video we will be seeing only Section 9, that restitution of conjugal rights. Let's see the meaning of restitution of conjugal rights. After marriage, both husband and wife have a right to live together and enjoy each other's company. This is called conjugal rights. If one spouse walks away or withdraws from the other without a valid reason, the other spouse can go to court for help. The court can then pass a decree of restitution of conjugal rights, which means the court will order the spouse to return and live together again. Conditions for restitution of conjugal rights. The court will grant restitution of conjugal rights only if these 3 conditions are fulfilled. 1. Withdrawal without reason. One spouse has left or withdrawn from the company of the other without any reasonable excuse, like cruelty or danger to life. 2. Truth of petition. The court is satisfied that the statements made in the petition by the aggrieved spouse are true and genuine. 3. No legal bar. There should be no legal ground to refuse the request. For example, if the marriage itself is invalid, restitution cannot be ordered. Next, about burden of proof. The spouse who has left, withdrawn must prove that they had a reasonable excuse. Example, cruelty, ill treatment, health issues. These can be valid excuses. If they cannot prove this, the court may pass a decree for restitution. Next is purpose of Section 9. To give the couple a chance for reconciliation and compromise. To prevent hasty separations over small or big reasons. to protect the institution of marriage by encouraging spouses to live together. Next, let's see the case law Sushila Bai vs. Prem Narayan. In this case, the court explained how Section 9 works. The court said, 1. First, the petitioner, aggrieved spouse, must prove that the other spouse has withdrawn from conjugal society. Conjugal society means living together as husband and wife. Though, once this is proved, the burden shifts to the spouse who left. That spouse must then show that they had a valid reason, reasonable excuse, for leaving, like cruelty, ill treatment, etc. Thank you for watching.